Okay, in 1987, Justice Rehnquist delivered the opinion of U.S. v. Salerno, responding to the alarming problem of crimes committed by persons on release. Congress formulated the Bail Reform Act of 1984, giving the citation of 18 U.S.C. Section 3141 et sequential as the solution to the bail crisis in federal courts. The act represented the national legislature's consider response to numerous perceived deficiencies in the federal bail process by providing for sweeping changes in both the way federal courts consider bail applications and the circumstances under which bail is granted. Congress hoped to give the courts adequate authority to make release decisions that give appropriate recognition if released. To this end, Section 3141A of the Act requires a judicial officer to determine whether an arrestee shall be detained. Section 3142E provides that if after hearing pursuant to the provisions of subsection F, the judicial officer finds that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person in the community, he shall order the detention of a person prior to trial. Section 3142F provides the arrestee with a number of procedural safeguards. He may request the presence of counsel at a detention hearing. I want to mark this statute. Hearing. He may testify and present witnesses in his behalf as well as proffer evidence, and he may cross-examine other witnesses. Upon appearing at the hearing. If the judicial officer finds that no conditions of pretrial release can reasonably assure the safety of other persons in the community, he must state his findings of fact in writing and support his conclusion with clear and convincing evidence. The judicial officer is not given unbridled discretion in making the detention determination. Congress has specified the considerations relevant to the decision of the government's Section 3141 of the government's evidence against the arrestee's background, and the government's evidence against the arrestee's background, and the characteristics and the nature and seriousness of the danger posed by the suspect's release. Should a judicial officer order detention, the detainee is entitled to expedited at-ballot review of the detention order. Respondents Salerno and Cafaro were arrested in March 1986 after being charged in a 29-count indictment alleging various racketeer, influence, and corrupt organizations violations, mail-in wire fraud, offenses, extortion, and various criminal gambling violations. The RICO counts alleged 35 acts of racketeering activity, including fraud, extortion, gambling, and conspiracy to commit murder. The respondent's arraignment. The government moved to have, so this is the arraignment now. So first we were talking about the indictment, 29-count indictment, now arraignment. The government moved to have Salerno and Cafaro detained pursuant to 3142E on the ground that no condition of release would assure the safety of the community or any person. The district court held a hearing at which the government made a detailed proffer of evidence. The government's case showed that Salerno was the boss of the Genovese crime family of La Cosa Nostra, and the Cafaro was a captain in the Genovese family. According to the government's proffer, based in large part on conversations intercepted by a court-ordered wiretap, the two respondents had participated in wide-ranging conspiracies to aid their illegitimate enterprises through violent means. The government also offered the testimony of two of its trial witnesses who would assert that Salerno personally participated in two murder conspiracies. The motion for detention challenging the credibility of the government's witnesses. He offered the testimony of several character witnesses. Faro represented no evidence at the hearing, but instead characterized the wiretap conversations as merely tough talk. So really, it's more like we've got an indictment, we've got an arraignment, and we've got a district court, and then what? They granted the government's detention motion. Concluding the government had established by clear and convincing evidence that no condition, so I'll say by clear and convincing evidence that no conditions of release would ensure the safety of the community or any person. Respondents appeal contending that to the extent that the Bail Reform Act permits pretrial detention on the ground that an arrestee is likely to commit future crimes, it is unconstitutional on its face. Over a dissent, the U.S. Court of Appeals for the Second agreed. Although the court agreed that pretrial detention could be imposed if the defendants were likely to intimidate witnesses or otherwise jeopardize the trial process, it found 3142E's authorization of pretrial detention on the ground of future dangerousness repugnant to the concept of substantive due process, which we believe prohibits the total deprivation of liberty simply as a means of preventing future crimes. The court concluded that the government could not, consistent with due process, detain persons who had not been accused of a crime merely because they were thought to present a danger to the community. It was reasoned that okay, so I'm going to say that on appeal, that was reversed as unconstitutional kind of deprivation of liberty. Because crimes are uncharged. Reason that our criminal law system holds persons accountable for past actions, not anticipated future actions. Although a court detained an arrestee, I feel like this is all analysis. Although a court could detain an arrestee who threatened to flee before trial, such detention would be permissible because it would serve the basic objectives of the criminal system, bringing the accused to trial. The court distinguished our decision in Gerstein v. Pugh, in which we upheld police detention pursuant to arrest. The court construed Gerstein as limiting detention to the administrative steps into arrest. The Court of Appeals also found the decision in Shaw v. Martin upholding post-arrest detention of juveniles and opposite because juveniles have a lesser interest in liberty than do adults. Part 2 of this decision, a facial challenge to the legislative act, is of course the most difficult challenge to mount successfully, since the challenger must establish that no substance under which the act would be valid. The fact that a Bail Reform Act might operate unconstitutionally under some conceivable set of circumstances is insufficient to render it wholly invalid, since we have not recognized and overbred the doctrine. I think respondents have failed to shoulder the heavy burden to demonstrate that the act is facially unconstitutional. Okay, so who said that? Was that the appeal court or the Constitution or the Supreme Court? I want to say the Supreme Court is saying it's not a bad argument, but it's insufficiently supported. So I think they're going to reverse appeal. I love how I'm just assuming. I got a lot more pages to read here before class. Just read the last one. In our society, liberty is the norm, and detention prior to trial or without trial is a carefully limited exception. We hold that the provisions for pretrial detention under the Bail Reform Act of 1984 fall within that carefully limited exception. We are unwilling to say the congressional determination based on, as it is, upon that primary concern of every government, a concern for the safety and indeed the lives of its citizens on its face, violates either the due process clause of the Fifth Amendment or the excessive bail clause of the Eighth Amendment. And so I was right in my presumption. Let's go like another 5 minutes. to Part A of this decision. Actually, it's two, the second paragraph, two before Part A. Respondents present two grounds for invalidating the Reform Act's provisions permitting detention on the basis of future dangerousness. First, so this is like the first issue, they rely upon the Court of Appeals' conclusion that the Act exceeds the limitations placed upon the federal government by the Due Process Clause of the Fifth Amendment. Second, they contend that the Act contravenes the Eighth Amendment's prescription against excessive bail. We treat these contentions in turn. So, Part A, the Due Process Clause of the Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law. This court has held the Due Process Clause protects individuals against two types of government action. So-called substantive due process prevents the government from engaging in conduct that shocks the conscience or interferes with the rights implicit in the concept of ordered liberty. When government actions depriving a person of life, liberty, or property survive substantive due process scrutiny, it must be implemented in a fair manner. This requirement has traditionally been referred to as procedural due process. Respondents first argue that the Act violates substantive due process because the pretrial detention and authorized constitutes impermissible punishment before trial. The government, however, has never argued that pretrial detention could be upheld if it were punishment. The Court of Appeals assumed that pretrial detention under the Bail Reform Act is regulatory, not penal, and we agree that it is. As an initial matter, the mere fact that a person is detained does not inexorably lead to the conclusion that the government is expressly intended to impose punitive restrictions. The punitive regulatory distinction turns on whether an alternative purpose to which the restriction may rationally be connected is assignable for it and whether it appears excessive in relation to the alternative purpose assigned to it. We conclude that the detention imposed by the Act falls on the regulatory side of the dichotomy. The legislative history of the Bail Reform Act clearly indicates that Congress did not formulate the pretrial detention provisions as punishment for dangerous individuals. Congress instead their legislative intent. It is more to do with the pressing societal problem. There is no doubt that preventing danger in the community is a legitimate goal, regulatory goal. So, legitimate interest. Nor are the incidents of pretrial detention excessive in relation to the regulatory goal Congress sought to achieve. The Bail Reform Act carefully limits the circumstances under which detention may be sought and to the most serious of crimes. And you see Section 3142F, detention hearings available in case of crimes involving violence, offenses for which sentence is life imprisonment or death, serious drug offenses, or repeat offenders. The arrestee is entitled to a prompt detention hearing. The maximum length of pretrial detention is limited by the stringent time limitations of the Speedy Trial Act. Moreover, as to Shaw versus Martin, the conditions of confinement envisioned in the Act appear to reflect the regulatory purposes relied upon by the government. As in Shaw, the statute at issue here requires that detainees be housed in a facility separate to the extent practicable from persons awaiting or serving sentences or being held in custody pending appeal. We conclude, therefore, that the pretrial detention contemplated by the Bail Reform Act is regulatory in nature and does not constitute punishment before trial in violation of the Due Process Clause. So it's not punishment, it's just kind of process. The Court of Appeals nevertheless concluded that the Due Process Clause prohibits pretrial detention on the ground of danger to the community as a regulatory measure without regard to the duration of detention. Respondents characterize the Due Process Clause as erecting an impenetrable wall in this area that no governmental interest, rationale, important, compelling, or otherwise may surmount. So, we do not think the clause lays down any such categorical imperative. We have repeatedly held that the government's regulatory interest in community safety can, in appropriate circumstances, outweigh an individual's liberty interest. For example, in times of war and insurrection, when society's interest is at peak, the government may detain individuals whom the government believes to be dangerous. Even outside the exigencies of war, we have found that sufficiently compelling governmental interest can justify detention of dangerous persons. So, interesting. Thus, we have found no absolute constitutional barrier to detention of potentially dangerous resident aliens pending deportation hearings. We have also held that the government may detain mentally unstable individuals who present a danger to the public, dangerous defendants who become incompetent to stand trial. We have approved of post-arrest regulatory detention of individuals, juveniles, when they present a continuing danger to the community, and this is all cited in even competent adults may face substantial liberty restrictions as a result of the operation of our criminal justice system. If the police suspect an individual of a crime, they may arrest and hold him until a neutral magistrate determines whether probable cause exists. Gerstein versus Pugh. Finally, respondents concede that, and the Court of Appeals noted that an arrestee may be incarcerated until trial if he presents a risk of flight or a danger to witnesses. So lots of reasons there. What I'm going to do is give it a second for me to get into class, and then I'll return, try to get to the second issue. Government's interest in preventing crime by arrestees is both legitimate and compelling. In Shaw, we recognize the strength of, strength of the state's interest in preventing juvenile crime. This general concern with crime prevention is no less compelling when suspects are adults. Indeed, the harm suffered by the victim of a crime is not dependent upon the age of the perpetrator. The Bail Reform Act of 1984 responds to an even more particularized governmental interest than the interest we sustained in Shaw. The statute we upheld in Shaw permitted pretrial detention of any juvenile arrested and further crimes. The Bail Reform Act, in contrast, narrowly focuses on the particularly acute problem in which the government interests are overwhelming. The Act operates only on individuals who have been arrested for a specific category of extremely offensive offenses, serious offenses. Congress was far more likely to be responsible for dangerous acts in the community, incapacitate those who are merely suspected of serious crimes. The government crime has been committed, right? Where are we? By the arrestee, but that is not enough. In a full-blown adversary hearing, the government must convince a neutral. Annoying, isn't it? Next page. 2 minutes late to getting into class. Come on, this computer is like the slowest thing on earth. 993-8906-8684, passcode 955304. Let's go. Can't even use this mouse. This is embarrassment. There's no reason to be 2 minutes late to class. There's no point in. On the next page, decision maker by clear and convincing evidence that no conditions of release can reasonably assure the safety community. As our cases hold, this right may, in circumstances where the government's interest is sufficiently weighty, be subordinated to the greater needs of society. We think that Congress is careful delineating those circumstances.
If you guys could all remember to mark present in the comments and keep your video on while we have the guests. So when you hear the district attorney that's going to be presenting to us today, I worked with her in juvenile court, her before she presents, but while you're listening to her, I want you to keep in mind everything we've been talking about, right? That the continuing pendulum between that always swings through legislative change